The issue concerns the president's authority to deploy federal troops, including active military personnel and federalized National Guard units, for domestic law enforcement purposes, often without the consent, and sometimes over the explicit objection of state and local governments. This practice directly challenges a fundamental American principle of separating civilian law enforcement from the military, a concept rooted in historical distrust of a standing army. The two key legal pillars governing this issue are the Posse Comitatus Act, PCA, of 1878, and the Insurrection Act of 1807. The PCA generally prohibits the use of the U.S. Army, Navy, Air Force, and Marine Corps for civilian law enforcement, like making arrests or conducting searches. It is a crime for federal military personnel to violate this act. However, the Insurrection Act provides the primary exception. It allows the president to deploy federal military forces domestically to suppress an insurrection, domestic violence, or unlawful combinations that hinder the execution of laws or deprive citizens of their constitutional rights, sometimes without state consent. This power is often considered a last resort. Recent actions have also invoked vague protective power or used non-federalized National Guard troops from other states to bypass the PCA, leading to legal challenges and accusations of executive overreach. Political reasons and immediate consequences. Political motivations. The recent surge in domestic military deployments, particularly in cities experiencing racial justice protests and political unrest, such as the 2020 protests in Portland or subsequent deployments threatened in cities like Memphis and Chicago, appears primarily driven by political objectives rather than a demonstrable failure of local law enforcement. Political posturing and base mobilization. Deployments are often framed by proponents as necessary to combat domestic terrorists, anarchists, or the radical left. This narrative appeals to a political base focused on law and order, often exaggerating the scale of unrest to justify the use of federal force. Executive authority assertion. The deployments serve to assert federal and executive dominance over cities and states governed by opposing political parties, undermining the constitutional balance of power and the principle of federalism. Inciting conflict. Critics argue that the heavy-handed, militarized presence of federal agents and troops often escalates rather than calm situations, aiming to provoke conflict that validates the initial claim of war-ravaged cities. Immediate consequences. The deployment of federal troops in a domestic civilian setting yields immediate negative results. Erosion of community trust. Militarized forces, trained for combat, interact with the public in ways fundamentally different from community police. This erodes public trust in all law enforcement and government institutions. Increased civil liberties violations. Military personnel are not trained in civilian law enforcement procedures, leading to numerous reported abuses, including wrongful arrests, illegal searches, and excessive force against citizens and protesters, often disproportionately affecting minority communities. Escalation of violence. Historical precedents, like the Kent State shootings in 1970, demonstrate the high risk of deploying combat-trained forces in volatile civilian environments. The use of force rules for the military are typically ill-suited for dense urban settings. Prediction and solutions. Prediction. Given the broad and vaguely worded authority granted by the Insurrection Act and the Supreme Court's historical deference to the executive branch on its invocation, the trend of presidents utilizing federal forces for domestic policy enforcement is likely to continue. Legal challenges such as the one filed by Los Angeles against a deployment over the governor's objections will test the limits of presidential power. However, as long as the Insurrection Act remains vague and the line between protecting federal property and performing general law enforcement is blurred, presidents will continue to use this authority for political ends. This will lead to further political polarization and continued tension between federal and state governments. Solutions and recommendations. To mitigate the risks to civil liberties and the constitutional separation of powers, legislative and policy reforms are urgently needed. Reform the Insurrection Act. Congress must update and narrow the Insurrection Act, defining clearer, stricter thresholds for its invocation. It should require meaningful consultation with, and ideally consent from, state governors before deploying forces under its authority. Procedural requirements, such as mandating a formal public order to disperse proclamation, must be strictly enforced. Close PCA loopholes. Legislation should be passed to explicitly prevent the use of non-federalized out-of-state National Guard troops, Title 32 status, in a manner that circumvents the Posse Comitatus Act and overrides the objections of the host state's governor. Mandate specialized training. If any federal forces, military or non-law enforcement agents like Border Patrol, are deployed domestically, they must receive comprehensive, non-lethal, civilian-focused law enforcement training appropriate for protests and urban situations, not combat. Ultimately, the deployment of combat forces in civilian life is a danger to both democracy and personal liberty. Addressing this issue requires Congress to reassert its oversight role and clarify the antiquated laws that currently grant the president virtually unchecked domestic military power.